also a fundamental principle of justice that a judge must be impartial and must appear to be impartial. Nabil el-Arabi, the Egyptian judge, had made many speeches while Egyptian ambassador to the UN attacking Israel. He also played a leading role in the emergency special session from which the advisory opinion request emerged. And afterwards, he gave a newspaper interview when he was no longer ambassador of Egypt to the UN, in which he referred to, quote, the atrocities by Israel on Palestinian civilian populations, Israel's recent occupation of PA headquarters, and its grave violations of humanitarian law. He even criticized the Palestinians and other Arab states for their failure to assert that Israel is occupying Palestinian territory in violation of international law, and for their failure to bring a case to the ICJ. He said, and I'm quoting from the article, I hate to say this, but you do not see the Palestinians or any other Arab country today presenting the issue thus when addressing the international community. Quote within the quote, Israel is occupying Palestinian territory and the occupation itself is against international law. Israel asked that Judge el-Arabi be recused. That request was rejected by the court. Thus, the court that decided that Israel's construction of a barrier to keep the suicide bombers out was illegal. That court included a judge who repeatedly attacked Israel in his capacity as Egyptian ambassador to the UN, as well as in an interview given when he was no longer ambassador, and urged the Palestinians to make the very claims that the court was now going to decide. Yet, this court thought that it was perfectly okay for him to sit of the court and decide the question. Incidentally, in contentious cases, a state that's not represented on the court can appoint a judge. But since this was labeled an advisory opinion, Israel had no such right. The court had 2 Arab judges, but no representative from Israel. Turning to the ICJ opinion itself, the court rejected the argument that it should not exercise jurisdiction, quote, because the request concerns a contentious matter between Israel and Palestine, in respect of which Israel has not consented to the exercise of jurisdiction. It stated, and again I'm quoting that, quote, the lack of consent to the court's contentious jurisdiction by an interested state has no bearing on the court's jurisdiction to give an advisory opinion. Why not? And the court here quoted and said, the consent of states parties to the dispute is the basis of the court's contentious cases. The situation is different in regard to advisory proceedings, even when the request for an opinion relates to a legal question actually pending between states. And why? The court's reply is only of an binding legal force. All right, keep that in mind when we get to discuss the conclusion of the opinion. In its decision on the merits, the court rejected the argument that defense was justified by Israel's right to self-defense under Article 51 of the Charter. Article 51 provides, in pertinent part, nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations. The court stated, Article 51 thus recognizes the existence of an inherent right of self-defense in case of an armed attack by one state against another state. However, Israel does not claim that the attacks against it are imputable to a foreign state. Consequently, the court concludes that Article 51 of the Charter has no relevance in this case. The court interpreted Article 51 as applying only in the case of an armed attack by one state against another state. Since the suicide attacks against which defense was to guard were not coming from another state, the court said Article 51 did not apply. There is, however, absolutely nothing in Article 51 that limits it to attacks by one state against another state, nor does the court cite a single authority in support of its position. It gives no reference to anything in the drafting history of Article 51, the court's prior decisions, the writings of commentators, or even General Assembly resolutions, which are not binding but which it cites in other contexts, to support this odd interpretation of Article 51. The court has simply added a new requirement which never existed and for which it cites no authority in order to conclude that Israel has no right to self-defense. Judge Rosalind Higgins, in a separate opinion, stated on this point, and I'm going to quote, I think Professor Pomerantz referred to that a little in her comments, "I fail to understand the court's view that an occupying power loses the right to defend its own civilian citizens at home if the attack emanates from the occupied territory, a territory which it has found not to have been annexed and is certainly other than Israel. Further, Palestine cannot be sufficiently an international entity to be invited to these proceedings and to benefit from humanitarian law, but not sufficiently an international entity for the prohibition of armed attack on others to be applicable. This is formalism of an uneven-handed sort." That's the end of the quote. It's kind of indicative of the court's attitude when you look at the whole opinion, that it used the words occupied Palestinian territory over 70 times. It did not use the word terrorism or terrorist attack even once, other than when quoting generally from statements by Israel. The court's conclusions. The court's conclusions include the following. A, the construction of the wall being built by Israel, the occupying power, in the occupied Palestinian territory, including and around East Jerusalem, and its associated regime, are contrary to international law. B, Israel is under an obligation to terminate its breaches of international law. It is under an obligation to cease forthwith the works of construction of the wall being built in the occupied Palestinian territory, including and around East Jerusalem, to dismantle forthwith the structure therein situated, and to repeal or render ineffective forthwith all legislation and regulatory acts relating thereto. C, Israel is under an obligation to make reparation for all the damages caused by the construction of the wall, etc. D, all states are under an obligation not to recognize the legal situation resulting from Israel's construction, etc., etc. You can read many, many more paragraphs. I don't have the time to do that, all of which refer to Israel's obligation. So although the court justified giving an advisory opinion in a case that was clearly contentious on the ground that its decision would not be binding on Israel, almost every one of its conclusions starts with the word Israel is under an obligation to. I had somebody do a count for me, and the court uses the term Israel is under an obligation 40 times in its opinion. And all states are under an obligation 9 times. This is an advisory opinion that the court says in the beginning will have no legal force, and justified its assertion of advisory jurisdiction.